Okay, I think we're probably ready to get started now. So thank you to everyone who's joined so far. And before we kick things off, I just want to welcome everyone on behalf of CAPS, which is Berkeley Law's Consumer Advocacy and Protection Society, along with our co-sponsors for today's events, which are the American Constitution Society, the Civil Justice Research Initiative, and the Center for Consumer Law and Economic Justice. And so I'm now going to hand it over to Gerald Singleton, a Berkeley Law alum, who is going to introduce Representative Porter. Thank you.
Thank you very much, Delaney. I appreciate that. So I know everyone's here to hear from Katie. I will not delay. I just want to say a few words about her. As many of you know, she went to Yale undergrad, Harvard Law School. She was a law professor in Nevada and Iowa, and then at UC Irvine. At Irvine, she was a founding member of the CJRI, which is the Civil Justice Research Initiative. It is the executive director is Ann Bloom. It's chaired by Dean Chemerinsky, and Katie, again, was one of the founding members. Katie is not only a congressman, but she was the first, congresswoman. She was the first Democrat elected to Congress in the 45th district. And if anyone is familiar with Orange County, that had been Republican territory virtually forever. When Katie first ran for office in 2018, not only was it a Republican district, but she was not even the choice of the Democratic establishment. Despite that, she won the primary and the election in 2018, and she won pretty handily in 2020. The thing that inspires me so much about Katie, in addition to all of the great things that she does, is the example that she's setting. I mean, she is proving that people with progressive, positive views can win in moderate districts. We're all familiar with the great work she's done in Congress, with her whiteboards of justice and her markers of truth. She has brought an energy to politics that is inspiring and invigorating. Whether it's grilling billionaire CEO Jamie Dimon over pay disparity, or analyzing the cost of a single pill of the drug Revlimid, I cannot think of a single issue that she is not on the right side of. She is exceptional, she is brilliant, and in just over 2 years, she has built a national following and become a leading light in the Democratic Party. Ladies and gentlemen, it is my honor to introduce Congresswoman Katie Porter.
Thank you so much, Jerry, for that introduction, and thank you to Ann Bloom for the invitation. As a member of Congress, I get asked to speak at a lot of events. And to start off with my trademark honesty here on display, some of them I'm more excited about than others. But I jumped at this opportunity because it's a chance to talk about one of my favorite topics, consumer protection. This is where my heart is. It's how I came into public service. And at its core, it's how I think about so many of the issues that I'm working on and fighting for in Washington. Consumer protection is important in good times and bad, but it's especially important right now, given the toll that this pandemic is taking on our country. Over 10 million people have lost their jobs. We're in an economic crisis. Small businesses are closed, and lines at food banks look like images of black and white Depression-era bread lines. And the federal government simply isn't doing enough to help real people. Now, I knew a thing or two about corporate special interests when I ran for Congress, having spent a lot of years fighting big banks. But seeing their influence up close and personal for myself in Washington has helped me realize just how powerful they are and just how much we need to come together as a community to stand up to them. While millions of Americans were hurting and still are, Senator Mitch McConnell's #1 priority was enacting a broad liability shield for corporations. Rather than leading the way toward the safe reopening of businesses and schools, he and his cronies in the Senate held up critical relief because they wanted to include sweeping immunity to shield corporations from responsibility when they recklessly failed to adequately protect America's workers or customers from the spread of COVID-19. Now, many of the same corporations that asked for immunity were themselves not providing workers with basic protective equipment or paid sick leave. The bill that McConnell was pushing was called, ironically, the Safe to Work Act. And that bill would have essentially required a worker or a customer, a consumer, to prove that a corporation committed a felony in order to pursue any case that had tangentially related COVID-19 harm for the next 5 years, including cases involving worker protection, discrimination, disability rights, and nursing home safety. And corporate immunity is just one of the many, many new fronts in the fight to protect consumers from predatory practices during this pandemic. Lawsuits, as we know, are just one of the tools available for consumers and workers to demand safer practices and fair treatment. And I'm hopeful that this will change with our new administration. But as we sit here today, access to the courts has never been more important. Ending mandatory arbitration is one of my top priorities in Congress. And I gotta tell you, there aren't a lot of fellow members who would say that is a top priority. Some of these consumer issues just don't come to the fore in communities and areas where we have to hear every day about healthcare, about jobs, about regulations, about the environment. But the solution to solving so many of those problems is robust consumer protection. And we can't have that without access to the courts and without ending mandatory arbitration. I was really thrilled to get language into the government spending bill in 2019 and again in 2020 that instructs the Securities and Exchange Commission, the SEC, to continue issuing no action relief to companies who exclude mandatory arbitration clauses from their shareholder proxy ballots. These definitions are these clauses are the definition of being anti-consumer, and I'm going to continue to keep tackling them from all angles. Last year, I did an interview with Seth Meyers, and before the show, they came in with just a little paperwork to sign. And being a lawyer, I still read the paperwork. And lo and behold, there in the contract was a mandatory arbitration clause. You can bet that I let the producer know why that provision is problematic and offered to go on stage and explain to a national audience exactly why mandatory arbitration is unfair. Now, the producer didn't take me up on it, and I wound up signing anyway, as so many of us do, because after all, I'd come to New York just to go on TV. But that experience left me ready to go back to Washington with a renewed fight to take on forced arbitration and to advocate for the passage of the FAIR Act, the Forced Arbitration Injustice Repeal Act. Consumer rights attorneys, like I hope many of you will become, are doing really incredible, necessary work to create meaningful consequences after the fact. But it's Congress's job to stop these harms from happening in the first place. I sometimes like to say, not really joking, that Congress's motto is something like solving yesterday's problems tomorrow, maybe. And that's how it feels sometimes, particularly when Mitch McConnell was hunched over the literally hundreds and hundreds of bills that the House had passed to the Senate during my first term in Congress, but he refused to bring any of them to the floor, like the HEROES Act, which passed the House in May of 2020, and which would have given our country $3 trillion in coronavirus help when we needed it most. I'm very, very grateful and hopeful to have a new Democratic majority in the Senate, to have retained the House, and to have the leadership of President Joe Biden. And I'm hopeful that we'll be able to start chipping away at the backlog of strong progressive bills that have been piling up over the last 2 years, including the FAIR Act. Most immediately, though, I'm cautiously optimistic that we'll finally be able to pass coronavirus relief legislation that we've been working on through a process called budget reconciliation. Now, I used to teach commercial law, and some of my subject matters and topics were not the most exciting. But I live for the moment when I can take something obscure sounding like budget reconciliation and explain to the American people how and why it will have a powerful effect on their lives. On Friday, my colleagues on the House Oversight Committee and I went line through one of the 12 bills that the House is putting together to create this massive $1.9 trillion package of targeted government funding. There are billions set aside for another wave of what my colleagues on the other side of the aisle call stimulus payments. I think that's a misnomer. We should be talking about them for what they are: survival or disaster payments. And there's also resources dedicated to helping meet the needs of state and local governments who are having to step up during the pandemic and provide more services. As the only single parent of young children in Congress when I was elected in 2018, I'm also a big champion of the expanded child tax credit. And I'm working today, in fact, to try to make sure that that tax credit doesn't include in it a single parent penalty, making it harder for single parents who represent a high proportion of households with children in poverty don't get hit with a more restrictive threshold for getting that help that they so desperately need. Last Congress, I joined the House Oversight Committee, and that is the main investigative committee in the House of Representatives. And it serves a purpose so central to the work that Congress does. It holds the government and large corporations and other entities accountable to the American people. And particularly since the start of the pandemic, I've worked hand in glove with this Committee on Oversight and Reform, we call it CORE, on a number of consumer protection issues related to COVID-19. I want to give you a couple of examples. Frontier Communications is a corporation that my office has been overseeing during the pandemic. We first reached out to Frontier last summer because we had technicians who raised concerns about a lack of PPE, personal protective equipment. Instead of hand sanitizer, Frontier offered its technicians degreaser hand soap, which the soap manufacturer confirmed was not approved to eliminate COVID. When the workers' union continued the push for hand sanitizer, Frontier offered them bar soap and told workers to use their thermoses of water, their coolers, to rinse their hands. To make matters even worse, Frontier technicians reported that they were threatened with disciplinary action for insubordination if they refused to enter a home to complete a job, even if when they arrived at that door, that customer was sick or coughing. On top of the obvious risk to Frontier technicians, traveling from one customer's work home to the next really can endanger public health. So we worked with the local union, we collected information, and we brought that information to the attention of the company's leadership. Needless to say, they got rid of the rule about the bar soap and the water jugs pretty quickly after that. Workplace protections, though, are only as good as the personal protective equipment that workers are using, as that story illustrates. And that's why I also wrote to the Food and Drug Administration about reports that Battelle Memorial Institute, a manufacturer or distributor, had misrepresented the effectiveness of a new mask decontamination technology. That technology, which is in use by frontline workers in California, and doesn't necessarily do what it says it's going to do to keep doctors and nurses and others safe. And no healthcare worker should have to worry about defective PPE during this crisis while they're fighting this pandemic. So I'm never going to support liability waivers for workers who expose dangerous conditions or customers who are exposed to avoidable risks. And I'm going to continue to shine a light on corporations that engage in that wrongful conduct. On top of protecting consumers from health risks, we've also been keeping an eye out for companies that are engaging in more run-of-the-mill predatory practices. While everyone's distracted fighting COVID, some of the companies have used COVID actually as an excuse to engage in predatory practices. For example, when the coronavirus pandemic began, Ticketmaster began refusing to issue refunds for ticketed events that had been canceled because of COVID-19. In fact, Ticketmaster even changed the wording of its refund policy to make it more difficult for its fans to get refunds. That anti-consumer behavior was unacceptable, particularly in the middle of a pandemic and the deep financial stress that millions of Americans were experiencing as a result of lost jobs and lost wages during the pandemic. So in April, I joined a congressional colleague in calling on Ticketmaster to issue immediate full refunds to all its customers. And we emphasized that Ticketmaster was holding hostage money that families needed to pay rent, their electric bills, to buy groceries. And as a result, Ticketmaster changed its policy to allow all customers to receive full immediate refunds for events that were canceled or postponed due to the pandemic. And speaking of run-of-the-mill predatory practices that have been around for as long as an industry has existed, a few months ago, the Committee on Oversight and Reform held 2 days of hearings with CEOs of big pharmaceutical companies. Under the leadership of our former chairman, Elijah Cummings, a true champion for real Americans, the committee had undertaken a deep investigation into the price gouging that had become so emblematic and is so emblematic of that industry. I had the opportunity to question some of these CEOs about drug pricing hikes, but the investigation uncovered were tied directly to executive bonuses. The CEO of a company called Celgene makes a cancer drug called Revlimid. That CEO made $500,000, $500,000 as a bonus just with Celgene raising the price of that one drug. For as long as corporations are allowed to prioritize maximizing profits at the expense of any other consideration, like having fair competition or protecting consumers, we're going to continue to see these kinds of abuses. I am a very strong capitalist, but as the pandemic has made all too clear once again, our capitalist economy is only strong if it has appropriate guardrails to do things like protect investors, protect consumers, address antitrust, and make markets transparent and fair. To do that, we're going to have to hold corporations accountable. What I found during the course of my career is that the biggest problem that most consumers and people have isn't that they don't have legal rights. It's that they don't have meaningful remedies. Businesses break the law, and unless consumers have the right to advocate and to hire advocates and to find advocates to fight for them, like the future attorneys on this call today, consumers will have to lump it. They'll have to accept the fact that to be a worker or a consumer or a patient in this country is to feel and often to be scammed and cheated. At the federal level, we need to see more and stronger protections for consumers, not weaker and fewer protections. Those stronger protections will in turn strengthen our economy. I know you have questions for me, but I'll stop there. But I'm really grateful to be able to join you in conversation today.
Thank you so much, Congresswoman. That was fantastic. Let me just go through, there's a ton of questions. I'll take as many as we can. And thank you again for your time. First one is, I would love to know if Representative Porter has any consumer-minded insights on the current Texas power crisis.
This is a terrific question. So I think one of the things that we're seeing here is an unwillingness to understand that when you allow market forces to play out, when you allow companies or entities to just think about short-term profits, they will engage in acts that have long-term dangerous consequences. So what we're seeing in Texas is that their decision to break apart from other companies in order, not for convenience sake, but in order to evade protective regulations that required certain kinds of safeguards, for example, to winterize the grid against extreme temperature changes. It's Texas's decision to do that that has left so many everyday Texans cold, hungry, without power, scared, and worried. And I think one of the things that's most important to realize here is the gap between what the everyday person in Texas is experiencing right now and the people who made that decision. And until we figure out how to give people much more of a voice in these decisions, we're going to continue to see big corporations lobby and get rules like this at the expense of everyday people. So I think it's sort of a two-part. What we see here is really illustrative of the typical consumer problem, where one part is that consumers are kept in the dark about what government's doing and what consequences or risks it might have for them. And then the other is, even when consumers try to raise their voices in times like now, there are arguments that are proffered that are really just straight out lies and efforts to evade taking responsibility for poor decisions.
Well said. All right, next question. Do you have any suggestions of what more local or state governments should do to fill in the gaps in federal consumer protection enforcement or oversight?
Yeah, so it's interesting because here in California, as you know, we have some local governments that are able to enforce consumer protection laws. It's not just our state's attorney general. And there are so many talented and amazing people who do that work. From a theoretical perspective, and from a theoretical perspective, I think it's easy to say we ought to allow for local enforcement or local enactment of regulations. People who are closest to the risks and harms know what kinds of regulations or protections consumers need the most. The flip side, when I've actually tried to spend decades educating not just consumers, but even law students like you about consumer rights, is that complexity is not a coincidence in the consumer protection system. It's a weapon. The web of complexity around consumer law is actually a tool that corporations and entities use to ensure that the law is so complex that the provisions around jurisdiction and around enforcement authority are so tangled that consumers end up not being able to seek remedies or get protections at all. And we've seen some of this in California, battles that have gone on between the Attorney General, state and local authorities, the federal government claiming huge jurisdiction over problems and then refusing to do anything to actually investigate or deal with those problems. That's exactly the story of what we saw with the mortgage crisis. The federal government claimed jurisdiction, said all of those state and local protections were preempted, and then the federal government proceeded to not actually enforce things. So I do think it's important for us to think about kind of where we want to allocate the energy. And my sense at this time is that we need local enforcement, and because we need more actors doing that enforcement work. It's just too difficult for consumers to find anyone, either a private attorney or anyone in government, who will even hear their complaint, much less be willing to investigate it or take action on it. I do think we have to be careful about how tangled and how complex we make the law, because I think one of the things that happens to consumers is they simply can't figure out whether the company has broken the law or not. And as they're asking that question, the company is sounding to the tune of millions of dollars of advertising and millions of dollars of lobbying that of course they don't break the law. Of course they care about customers. Of course safety is first. And so I think we have to think about that complexity, not see it as a coincidence, but understand it as a weapon of the sophisticated against the harried, tired, just trying to get through the day consumer that all of us really are.
Thank you. Okay, next question. What can be done, or what is being done, to address and recover stimulus, or more accurately, survival or disaster payments that was stolen by big corporations and wealthy people who it was not intended for?
Yeah, so one of the issues in general with, and this goes to the point I was making about complexity, with any government program is sort of the narrower you draw the criteria to make sure that no undeserving person gets it, the harder you make it for regular everyday people to get it. And there's actually really interesting, and I'm sure Anne knows about this, but there's really interesting, and more could be done, research around this that shows, for example, when states try to crack down on what they assert to be welfare fraud, what happens is that the most needy drop out. They can't fill out the paperwork. They can't find the documentation. They don't have a fax machine. And cheaters are actually quite sophisticated at cheating. I mean, this is their full-time job, cheating. And so we saw this in the mortgage crisis, that the lowest income, non-English speaking, most vulnerable homeowners couldn't begin to meet the demands of the banks and the government programs for paperwork to save their houses from foreclosure. But cheaters were perfectly happy to fabricate documents, right? And this is, a lot of them moved in from cheating people into buying houses to cheating people into trying to keep houses. So when I think about the stimulus payments, the fact that somebody got one that they weren't supposed to, I don't think is nearly as big of a concern as how and why it took so long for the government to be able to get those checks to the most needy. And this included people who had lost their jobs, because if your income changed a great deal between 2019 and 2020, you were ruled ineligible for that stimulus, right? And I think we have to instead think about how can we give these things out on a more broad, universal basis that creates political goodwill, that reduces the cost of administration, and it prevents a lot of these concerns about waste, fraud, and abuse. So I deeply sympathize with the idea that we want those who need help to get help. But I also want to tell you that I think we are constantly told that there's not enough. There's not enough to help everybody. So we have to put all of these things in place, these hurdles and these jumps and these barriers, to make sure that only those who need it get it. But in practice, what that really means is that many who need it don't. And so I think we're constantly balancing that tension. Now, I think that's really different than some of the problems that we've seen, for example, with the Paycheck Protection Program, where Congress simply did not write anywhere near the appropriate amount of transparency and guardrails into the Paycheck Protection Program. There is no way that my colleagues in Congress should have been applying for Paycheck Protection Program loans and getting them. We had lots of companies who applied, and some of them kept it, some of them returned it when they were publicly shamed. But that was an example of a program where Congress said open to all comers. And then when everyone came, we were upset and tried to claw back the money and try to get transparency. But you really have to build those things in, I think, on the front end, because after the fact accountability is I think, I'm not telling any Jerry here or any lawyer anything that they don't know. After the fact accountability is a rather cold comfort because it's the harm has been done. People have taken money and drained the PPP program funds, leaving other businesses that shuttered themselves before Congress could act to put more funding there. So I do think we always want to worry about waste, fraud, and abuse, but I think we have to do it with an eye to understanding that you have to, build that up front, not just try to do it after the fact and say, oops, who knew that would happen? I mean, anybody who says, who knew people would try to cheat the government with the Paycheck Protection Program? I mean, hello, right? So we should have foreseen that, built that appropriate system, and then had that transparency right from the beginning. And when you try to do it after the fact, I think you've already lost in so many ways.
Agreed. Do you have time for one more?
Mm-hmm.
Okay, great. And this is a topical question. And my understanding is you have to take off at 1:30?
I think 1:35.
Oh, good. Okay, great. Then we can hopefully do a couple more. So this one is directly on point. Representative Porter, do you have any advice for law students who are interested in working in Congress to help legislators enact progressive policies and protect consumers?
Yeah, I do. And I miss being able to give out this kind of advice. When I was a professor, I was always so thrilled when students would come and talk to me about how to protect consumers, how to make that their career. I have a couple pieces of advice. One is it's really important to understand that for people who want to help those in need or to address kind of the inequalities and the unfairness of our system. And I used to tease Erwin Chemerinsky about this, a constitutional lawyer. And I used to tell him, look, the biggest problem that poor people have is not that their constitutional rights are being trampled. It's that they're poor. And it's because they're poor that their constitutional rights are trampled, right? And so I think one, I would encourage people to take some business law courses, whether that's tax, whether that's commercial law, bankruptcy law, all of those things really are important in understanding kind of what are the levers available to Congress to address economic inequality, to make our economy more fair. Our tax code is a major way that we attempt, and I say attempt because I don't think we're that good at it, but it's a major way that we attempt to address some of the unfairnesses in capitalism, for example. So not that you shouldn't take these, do-gooder sounding public interest courses, but make sure you take some commercial and business law courses, because at the end of the day, what most clients and most consumers need and want is resources to address what happened to them, to right the wrong, whether it was, a lost limb or lost money. Resources can help correct that problem. I think the other piece of advice I have is, and Berkeley's wonderful this way, is to do something either during or before or after law school that exposes you to what it's like for consumers to try to navigate. I think too often when we become lawyers, we say, well, here it is. Here's the answer. I found it. And good for your legal research professor. But what you're missing during that time is, as you become a more skilled lawyer, as you become better at finding statutes and reading regulations and doing legal research, it's easy to get farther and farther away from remembering just how hard that is to do for everyday consumers. And how should we address that problem? Whether it's expanding access to lawyers, whether it's protecting the right to the court by ending arbitration, whether it's thinking about more self-executing kinds of remedies rather than ones that require people to litigate. I think that remedy piece is really the missing thing. And so I think my colleagues spend way too much time in Washington saying, press conference, we gave consumers this right. And meanwhile, there's no lawyer who's going to take that case. There's no effort to teach workers or consumers or employees about what their rights are. And disclosure, really in my sort of world of thinking about this, disclosure is really a 4-letter word. Disclosure is what companies use not to give information, but to hide information. And they hide behind the fact that they have disclosed to get over the fact that consumers actually had no idea what was going on. So I think a course or some thinking or research around how do consumers get information, how do they process it, how do they make decisions. One of the most valuable things I ever did when I was working as the foreclosure monitor under Attorney General Harris was get to know some of the people who did marketing for credit cards at the big banks. And I learned from them all of the ways that the bank knew how to communicate with consumers when they wanted them to take a credit card, but they were refusing to use when they were sending information to consumers about how to save their home from foreclosure. So I think thinking about how do you translate what you know into people's lives? The knowledge that you're gaining in law school isn't for you, it's for all of us. Just like doctors, you too have people in need that you're going to want to help and treat and make them better and make their lives better. And so really think about their perspective as you go through law school, even as you become more skilled. Remember what it's like to be a consumer, to not know, to not be able to find an answer, and to be really scared and afraid and alone. And I think that perspective from my consumer work that I took to Washington really is what drives sort of how I think about questioning in virtually every hearing.
Well, thank you so much. It's just past 1:35. I cannot thank you enough. You are truly a breath of fresh air, and we really appreciate it.
Thank you. And everyone reach out, apply for internships, get that service, become plaintiffs' lawyers, fight the good fight. We need people alongside. I need a next generation coming down the pike. So thank you so much, everyone, for having me. And thank you again, Jerry and Ann.
Thank you.